.gov. We are currently in year 5 of the 7-year consent decree. Here today to provide an update on the consent decree implementation and an overview of the 7th O'Donnell Monitor Report are independent court monitor Professor Brandon Garrett, Deputy Monitor Professor Sandra Guerra Thompson, Seth Hopkins, representing the Harris County Attorney's Office, and the Honorable Shannon Baldwin, representing the County Criminal Courts at Law. After the updates, we will allow public comments and questions. With that, I'll turn the program over to Professor Garrett to start us off.
Great. Thank you so much, Natasha. It's a real pleasure to be here and to share the podium with my friend and collaborator, Professor Sandra Guerra Thompson, and with Seth Hopkins from the County Attorney's Office, and with Judge Baldwin. It's wonderful to see other judges, the Office of Court Administration, other collaborators, and members of our community working group, members of the community here. We haven't had this big an in-person crowd at one of our meetings for some time, but we are meeting less often now. We're meeting annually. And we were really pleased to share with Judge Rosenthal and with the community our 7th report on March 1st. I wanted to give you an overview of some of our ongoing and updated findings and some of the real remarkable accomplishments of all the people throughout Harris County that have been working so hard to make the O'Donnell Consent Decree a reality these past 4 years. Kind of can't believe it's been 4 years. The report, looks like some of our other reports, but there's some real new things that we have to share with you, including some things that will be new to share with you today that are not in the report. I suspect Seth Hopkins will tell you more about my Harris County case. Remarkable work has been done, and the County Attorney's Office, and Seth in particular, took the lead on developing it for submission to us and the parties a plan, which the consent decree called for, to improve court appearance, to both improve access to courts, to encourage people not to miss their courts, obviously very important to the efficiency of the dockets and to the work of our judges, but also important to people's outcomes, that they not miss court unnecessarily. And that work came to fruition in a really quite remarkable plan that was approved last year. And big chunks of that plan have been implemented with incredible speed and with wonderful results. And so we'll have that to share. People will leave, the JPC with a lot more information and a much more convenient ways to find out what's going on in their case, which is just wonderful. In our report, we share updated data. There's a lot of hard work that the county does to provide district court data with us. Some things remain the same and have, ever since we started this work. We've continued to see, in general, a decline in the number of misdemeanor arrests in Harris County, and the same rate and declining numbers of people rearrested for misdemeanors in a year following the arrest in question. And so, for example, for last year, for 2023, it was about 41,000 misdemeanor arrestees, and it was 22% of them that were in 2022 that were rearrested again in 2023. That rate was 23% before this consent decree started, and it was many more people, because back in 2015, 2016, it was more like 50,000 people a year arrested for misdemeanors. And so the system has shrunk, but fortunately, we've seen positive public safety outcomes among the people who are arrested for misdemeanors. Harris County has credit to take for a lot of surrounding work regarding people who are unhoused. We see some of that in our data. The share of people who are flagged as homeless and arrested for misdemeanors has modestly declined. It had been over 10% before the consent decree. It's about 8% now. There are obviously a lot of things that affect the homeless population in a big place like Harris County. In general, far fewer people in misdemeanor cases are in the jail. Many more are eligible for general order bonds for prompt release at the point of booking. And, we now see that, about 60% of people are released on general order bonds, another 28% on personal bonds. The legacy of Hurricane Katrina and then the pandemic really affected our judges' dockets. What we have seen, though, since sort of as the pandemic has receded, is remarkable accomplishments among the judges. Last year's data was particularly striking. We've seen that the number of cases, misdemeanor cases, disposed within a year, turning from what happens at bail to the case as it progresses, is almost 70%. It had been more like 45% in 2020. It's a really remarkable change, and it's a testament to the hard work of our judges. We also talked about some hurdles in our prior monitor report, where the county invested in a really quite remarkable electronic court notification system so that people could get text or whatever electronic notification is convenient for them. Their choices of different languages. It was an excellent system that was designed, but there was some sleuthing. It was uncovered that it just seemed odd that not as many people as we expected were enrolled in that program. Some issues were identified in terms of the enrollment process. And at our last meeting, we described how county officials worked really hard once those errors came to light to plug those holes and fix those problems extremely promptly. So we now have some months behind us and can describe what it's been like now that really large numbers of people are being promptly enrolled and getting these additional reminders that they have court dates. And consistent with the research on notifications, certainly helps me when I get a notification about a prescription that I need to refill or a dentist appointment. It's important for court too to be able to easily tell when you're supposed to be there and when you're not. In our last report, we described how enrollment went up enormously, particularly among people with general order bonds, went up to 60% from like 25%, big change. But we also saw a noticeable change, noticeable decrease, more than a third, 35% decrease in non-appearance at arraignment at that first appearance. And that's a really important court appearance in terms of getting a case started. So that was a really positive initial outcome. We suspect that as more people get enrolled in that, as more people use these materials where they can quickly go on my Harris County case and just check in on, which of the courts am I supposed to be at? Is this an appearance that's coming up soon? Is it not? We hope that there are positive benefits for people and for our courts as these improvements get rolled out. We've talked before about how people sort of talk about misdemeanor bail reform in Harris County as if it happened overnight when the consent decree was entered or when Rule 9 was adopted before the consent decree. But actually, a lot of the really important pillars have taken incredible hard work, which we can only applaud and observe. We can't take credit for it. And many of the people in this room do deserve the credit for the really hard work that it has taken to implement these systems and to bring them online. And so we're thrilled that so many of them have come online. And we have some more to share, and we also we have so many more people here than usual. We're really excited to get some questions. We hope we do. But I'll turn things over to Sandy and then Sarah and Judge Bolton.
Thank you, Brendan. So hi, yes, again, I'm Sandra Guerra Thompson. I'm a professor at the University of Houston Law Center. And I serve as deputy monitor. So I'm one of the local people who's involved in this project. And, just to step back again, what the O'Donnell Consent Decree really did was it flipped the system where it used to be that almost everybody was required to pay money to be released on misdemeanor cases. And now, at least with regard to misdemeanor cases, most people are not required to pay money anymore. And that has had a huge impact on the community. So, my role in this job is working with the team that also includes Dr. Dottie Carmichael and her team at Texas A&M University, as well as the officials in Harris County who are involved, starting with Dr. Natasha Willis, who is the project manager for O'Donnell and heads up, is part of a larger team of people who are dedicated to all of the really sort of heavy lifting projects that are ongoing as part of the change. Because, I used to hear judges say, well, it's a big county, it's a big system, it's like a ship and it's going to turn very slowly. You can't turn it on a dime. So these are some ongoing projects that we're involved in, but we're thrilled about the non-appearance project. That was a major one, major accomplishment to get those things rolled out. But on an ongoing basis, we're really excited about all of the community partners that we have and that we continue to try to cultivate. Just, to give you some sense of it, it's a pretty wide and diverse group of people, because when you think about people who get caught up in the system and get stuck in jail, it affects a lot of different groups of vulnerable people. So we're really blessed to work with advocates like the Texas Criminal Justice Coalition, the Bail Project, Tahari that works with women and immigrants, the Houston Area Urban League, the Greater Houston Coalition for Justice, Beacon that serves the homeless population, Angela House that serves women who are, trying to improve their lives, the Texas Jail Project, that does incredible storytelling about people who are in jail, Healthcare for the Homeless, Search that also serves the homeless population, Foster Care Advocacy Center. Foster kids are another category of really vulnerable people that get caught up in these, they get an arrest and then there's nobody there to help them. So the U.S. Vets is another group that helps homeless veterans. That's another segment of the population that we're, concerned about. Various medical groups are also interested. People go in the jail, they don't have their medications. It becomes a health crisis. The Downtown Business Association always has concerns about, their businesses and the environment in which they try to operate. And then we have retired members of Houston Police Department that work in a formal way with us, as well as a former U.S. Marshal. So, we have law enforcement's experience also guiding us in some of the work that we're doing. And we're really grateful to a lot of different Harris County agencies. I could go on and on, from the Sheriff's Office to the District Attorney's Office that has recently started having people at the jail to try to reduce the number of charges that are being brought into the jail, like have police officers do other things besides charging people with crimes and trying to get them out of the system. And they're operating a number of other different diversion programs as well to get charges dismissed on people who complete programs. So we're really grateful for those efforts and hope to further expand them. So it's a community effort, and we're again, if anyone's out there who wants to be involved in the ongoing work that we're doing, please reach out to me, and I'll turn it over to Seth.
Thank you so much. And there, that's what I was supposed to do. Thank you. Good afternoon, and thank everyone for being here. We really appreciate it. The county attorney's primary role is to provide legal support for our stakeholders. But as the monitor mentioned, this year we've been working on the Section 55 project. And for those who don't know, Section 55 of the consent decree requires the county to come up with a plan to assure that people show up for their hearings, particularly their first appearances. So we've come up with a plan, and this is a copy of the plan. It's available online for anyone who wants to read it. And we started with the low-hanging fruit, the question of people who are arrested for maybe the first time. They don't understand the system. They don't understand what's expected. They don't understand, for example, that their first appearance, which is usually about a week after they're arrested, it's not their trial. They don't have to have their evidence. They don't have to have their attorneys. It's just a first appearance. So part of what we realize is that we need some education. And so one thing that we're doing, that we're working on currently, is we have 48 hours, up to 48 hours that people are often in the Joint Processing Center. And so we realized we can use that as an opportunity to have educational videos for them to understand what the process is like, how to get through security when they get to the courthouse, what happens at a first appearance, all of that kind of stuff. We would rather them hear it from us than hear it from the person sitting next to them as they're waiting in the jail. So that's one of the things that we're working on, one of the future investments that we're talking about, and we're working closely with the court administration and pretrial services to come up with those videos to help people. But the first low-hanging fruit that we realized is that a lot of people don't even know when their hearing is or how to get there or those sort of logistical questions. And what we understood was when you came out of the jail, you were given a piece of paper and it told you about this first hearing. But what we learned was 37% of people lost that piece of paper. So we started with something really obvious. Let's put the piece of paper in a folder, and the folder can can provide you with other information that you need about your hearing. And then we realized that if you, for whatever reason, lose that piece of paper, we have the text notification system. Let's build on that. We have we have excellent infrastructure set up for people to go online and learn about their hearings. But the problem is it was very complex for people to use. So for example, a lot of people don't realize that in Harris County, we have both a district clerk and a county clerk. And if you go to the county clerk's website, you're not going to find out anything about your hearing. You've got to know to go to the district clerk website. And once you go to that website, for security reasons, you have to have a username and password. All of these steps we found were an obstacle to people being able to find out about their hearings. So we worked very closely with the district clerk and we created this myharriscountycase.com portal. By the time people come out of the jail, we hope that they will have heard the phrase myharriscountycase.com a bunch of times, that they'll understand what the website is and that they'll understand how to use it. So how do you use it? You go to that site, you type in your last name, you type in your date of birth. That's it. That's the only information that you need. And what will come out is only the information that you need in simplified form to get to your hearing. It'll tell you what your charge is, what your arrest date was, your SPIN number, the location of the hearing, the judge will be hearing it, what the hearing is about. That's it, just the basic information. And once that hearing occurs, that disappears off the website. So it is a simple tool that gives you as easy as possible the information that you need. So we were actually in the process, and Natasha just provided us hot off the press. We have posters, we have QR codes. These will be throughout the jail. You'll see these as you're going throughout the corridors in the jail. The Joint Processing Center will be distributing them to the defense bar. We'll be distributing them to any stakeholders who need them. I went through and checked the census reports and found the top 5 languages spoken in the Harris County, and these will be in all 5 of those languages. And I think we talked about the QR code. Eventually, part of the technology infrastructure that we're coming up with will be smartphone apps so that you can download the apps and it'll help you keep track of your case. That's coming a little bit down the line. We started with the easy part. Let's get the website out. Let's get the basic infrastructure. And then from there, we can build. So that's what we've done so far. Some of the other projects that the Section 55 plan is addressing, we realize that if you go to the courthouse, your hearing may last a lot longer than you expected. Your cell phone may be your lifeline for your transportation, checking on your kids, all of the things that you need to do to manage your life. And the court administration is generously allowed us, and we haven't done this yet, but to put cell phone charging stations for people to be able to charge up their phones. And we're also going to work with them about some wayfinding kiosk and other infrastructure. And what we really wanted to focus on was putting permanent infrastructure that will be around for a long time and that will benefit everyone, any user of the system. So that's what we're doing on the Section 55 plan.
Good afternoon, everyone. I'm Judge Shannon Baldwin. I am the judge of Harris County Criminal Court at Law Court. Hope you got that first part. I'm also the presiding judge for all of the 16 criminal courts, criminal county courts. I'd like to first obviously thank the monitors for their continued work in documenting our compliance with this progress. I'd also like to thank our justice partners who have been working closely with us in our efforts to ensure Harris County has a constitutional bail system. As it relates to bail reform, the Harris County Criminal Courts at Law are committed to ensuring safe and effective bail reform. Misdemeanor bail reform is designed to level the socioeconomic playing field. It ensures that no one remains in jail simply because they cannot afford to pay to get out. Bail is not meant to be a tool of oppression, but a way to maintain public safety and ensure that defendants who are presumed innocent under the law simply return to court. Focus is now on whether the person is considered a danger to the victim or the community, not whether they can afford to pay. Appropriate bond conditions, protective orders, pretrial supervision, and other conditions are also used to help mitigate potential risk, with the goal of setting effective but not excessive conditions. I may talk to you a little bit more about some other concerns that the courts have, particularly, and I know I'm hoping you all have heard a little bit about it, this backlog and resources that we have available to us. We are, and I'll say this 10 times over, extremely proud of the work that the misdemeanor courts have done and are continuing to do to reduce the misdemeanor case backlog. Since January of 2022, we've cleared 126,000 cases overall, an average of 7,896 cases per court. During that same time frame, we've cut the number of backlog cases by 65.7%, from 24,457 to 8,387 cases across our misdemeanor courts. That's like lightning. If it were proper, I'd do flips and everything else and jump up and down. I just want to make sure y'all caught that. That's pregnant pause. All right. Our average clearance rates have trended well over 100% and as high as 137% just this past February. We're doing this by placing a sharp focus on best practices, good leadership, and data-driven decisions. We've attended training sessions, conducted court assessments, developed action plans, and updated our forms and practices to ensure we're operating as efficiently as possible. As it relates to our resources, our continued success comes despite our limited resources. Harris County has almost 5 million residents, and it's still growing. It's the third largest county in the United States, behind only LA County in California and Cook County in Illinois. National standards call for a jurisdiction the size of Harris County to have 27.5 criminal misdemeanor courts. We have 16. That's a significant delta. To that end, we have begun the process of asking the Texas State Legislature to create and the Harris County Commissioners Court to fund additional courts. We hope to have additional updates about this request at our future meetings. In conclusion, thank you again to the monitors and our justice partners, and to all who are attending today. Ensuring safe and effective bail reform is an important issue. We appreciate your interest, and I look forward to any questions you may have.
Okay, thank you so much for that review and for the updates from the criminal courts and the county attorney's office. We will now begin the question and answer portion of this meeting. We'll start with in-person questions and then take questions from our online audience. So online audience, if you have questions, please put them in the chat. For those in person, if you have a question, please come to the podium and state your name and affiliation in the microphone before asking your question. And then for those online, when you list your question, please also put your name and affiliation in the chat. And as soon as we finish the questions for in-person individuals, I will read the ones off of the chat. And so if anyone has any questions, we'll take them now. And so just remember to state your name, please, and your affiliation.
Thank you.
Hi, I'm Ray Brackens with the Texas Organizing Project. Good afternoon, everyone. My question is, we have a mass incarceration problem in Harris County. Our jail is over capacity. How have the O'Donnell's bail reforms helped keep people out of jail when they simply cannot afford to bail out? Do we have a way to quantify the percentage of additional people in the jail at a given time over a period of time if these changes were not made?
One thing that we're working on sharing with you is a way of quantifying not just how the number of people would have been different had these changes not been made, but what have been the cost savings by adopting these Rule 9 and other reforms. And we've been doing a lot of hard work. We have some very preliminary figures, which will definitely be ready for our next monitor report, maybe much more detailed analysis coming. I mean, in general, there's been this incredible reversal where, very few people are detained in misdemeanor cases. And the vast majority were before, although in some ways, Sandy put it well, where she said most people, were released in misdemeanor cases both before and after these reforms, but they were released after pleading guilty, often after several days in the jail. People weren't detained for long times, but they were detained after paying or after pleading guilty. And because they couldn't pay, either they would pay or they would plead guilty. So that's been an enormous change. And those short jail stays still added up to a lot of people and a lot of hours in the Joint Processing Center, where, about a third of the JPCs, my understanding, was misdemeanors. People arrested on misdemeanors before these reforms. And now it's, hundreds of cases, but most of the people with misdemeanors in the jail are there. They have a companion felony, or there's an out of county or an immigration hold. There's some other reason why they're there. It's very uncommon. Although sometimes there is a serious concern in a misdemeanor case, but for the most part, there are very few misdemeanor only cases in the jail, which has had if 3,000 people like before these reforms were in the jail on misdemeanor cases, low level ones every day. I mean, I don't know what would happen with the system, but it wouldn't be tenable.
Right. Specifically, 10%, actually less than 10% of misdemeanor defendants are actually in jail at this point. 10% over their overall population. Only 3% of our active cases in custody. And then 8% of those that are held within that are actually held for other reasons, like you mentioned, Brandon. So like ICE holds, or they have felony pendings. So those are the reasons that they're still in custody. So we are a very, very, very minor, if you will, drop in that bucket in terms of our population in this court.
Thank you, Judge. Any other responses?
We would like to say more, though, and we'll share more in our future reports, just about the larger cost savings. Because it's not just about the cost of and what the person endures, being in jail when they didn't have to be, when the case could have been resolved another way, but there's also the loss of employment, loss of income in the community. And so we're working on quantifying those costs as well.
Okay. Thank you for your responses.
Good afternoon. My name is Seneca McQueen Jr. I'm a member of the Texas Organizing Project. A question for you today. Our criminal justice system often arrests Black and brown communities at higher rates. Has Harris County seen any changes in the racial disparities in pretrial releases since the consent decree was enacted? And if so, can you give me like percentage, numbers, data, brief?
Sure. So in terms of the difference in Black versus white defendants, Latinx versus white defendants in release rates, those were really racially and ethically disparate before these reforms. So there was, about a 10% difference in Black versus white release rates, back in 2015, 2016, 2017, before these reforms. About the same in Latinx versus non-Latinx defendants. about a 10% difference, pretty marked difference in who would end up in jail and who wouldn't. And that disappeared once these reforms took effect. So we don't see those disparities in who ends up in jail or not. And overall, far fewer people end up in jail on misdemeanors. Now, what hasn't changed in that way is just the makeup of people who get arrested for misdemeanors. And that's, vast bulk of people arrested for misdemeanors are either Black persons, Latinx persons, and minority or white persons based on the data we have.
Anyone else want to add anything else? All right, thank you for taking my question. Have a great day.
Good afternoon. My name is Cecilia Fontenot, a member of Texas Organizing Project. My question to you all is, some cases lack the evidence to make it through trial. Before O'Donnell, people would languish in jail. How has the O'Donnell case helped dispose of cases, and did that result in Harris County taxpayers saving money? That's the first question. The second one is, if so, how much did the county save by disposing of some misdemeanor cases?
On the cost savings, we're still working on that. I mean, in general, one thing you see when you look at the costs of the misdemeanor system is that, the time that people spend in jail is expensive. Jails are expensive places. And on the flip side, some of the reforms that have improved the fairness of what happens in court, having a public defender there at the bail hearing, those are relatively inexpensive. Like those are kind of drops in the bucket, actually. Some of the due process that's being provided under this consent decree and through the hard work of public defender's office, courts themselves, those changes have been really cheap by comparison with, every time you identify someone who doesn't need to spend 3 days in the jail or even, 24 hours in the jail, 18 hours in the jail, those hours are expensive. But the detailed process of doing the full cost benefit analysis, that's taken a lot of collaboration, by the way, because we're costing out, how much does it cost for, an hour of a judge's time, an hour of a prosecutor's time. We've been doing hard work, and really we meaning the incredible team at Texas A&M, at PPRI, Dottie Carmichael, David Shee, who's here, and colleagues. But in general, like what we've described, that there are very few misdemeanors who spend those hours and hours in the Joint Processing Center. And when they do, it's a more serious case where there's a bond hearing, there's a public defender there. That's much less expensive than the system where you had before, where, most people were in misdemeanor cases were spending that time waiting for their bail hearing, many of them detained afterwards. That was a really expensive process. Now, what happens, if now is that, most people have their freedom, return to their community, their case goes forward. And over time, lawyers do look at the case on both sides, present evidence to the judge, or they negotiate something. And mostly they don't negotiate a guilty plea anymore. For the most part, these cases are being dismissed. And like Judge Baldwin talked about, like I highlighted up front, that's happening much faster. You still don't have very many misdemeanor cases going to trial, but we don't have that many criminal cases going to trial in terms of percentages in any courtroom in this country. But what we have seen is that, many more people are receiving dismissals and acquittals in these cases. The convictions are less than a third of the cases resulting. It's kind of the reverse. It used to be like 2/3 of people would plead guilty, often within days, maybe without seeing a lawyer, which was a real constitutional concern. Now that doesn't happen. And over time, many more of these cases are dismissed. And that may not be because the case didn't have merit or there wasn't evidence. Sometimes the parties might realize that. Sometimes it may be that the person complied or received some resources or supervision, and everyone was satisfied that they shouldn't have this case hanging over their head anymore. You know, public safety has been satisfied. This person's doing well in the community. We don't need them to come into court anymore. Don't know if you want to add to that.
I think that's right. And, you know, the other thing is in terms of savings to the public, right? Since we had thousands and thousands of people who were having to pay money to get out of jail needlessly in the past, and now they're not, you know, that's money that they can use to buy groceries for their kids and gas. And, you know, so there's a lot of savings to the community in that regard too. So that they're not having to spend as much money just to get out of jail.
Really think, as it relates to O'Donnell, first of all, O'Donnell is bail and failure to appear focused, right? But the ultimate, you know, cost benefit to really the community as a whole we might even say is immeasurable. The fact that people are no longer having to sort of, you know, sit in jail for days without having any access to the court, that we actually were able to make that immediate change. That's an immeasurable amount to their lives, right? They don't lose their homes, their lives, their livelihood, waiting for something to happen there. I would even go so far as to say O'Donnell was an expression really of a mentality now of maybe the court system as a whole. It's meant to be fair to everybody. So every process of it is going to look for the opportunities to be fair, to make sure that access is given to those who deserve it. And all of that is going to equate to a cost savings at some point. What that may quantify per dollar, I don't know that answer. But I can tell you we are focused on making sure that those opportunities happen. So we have higher trials being set, right? Higher levels of trials. So people aren't pleading just to get out of jail. They aren't pleading just to hurry up and get rid of a case. They understand that this court has a reason. It's there for a purpose, not just to rush you through that process. And then also alternative sentencing. We have PTIs, pretrial interventions. All of those things are put into place and tools utilized by the courts, which ultimately will have cost savings to everybody.
Thank you. Any other comments? No? Thank you very much.
Good afternoon.
Afternoon.
My name is Lisette Ramirez. I'm a member of Texas Organizing Project. My question is, there has been a misinformation campaign claiming that reforms of cash bail has threatened public safety. Is there any additional information you can share on this issue?
We weren't sure what we would find when we started this work 4 years ago. And I understand why people were concerned with such a big change, such a big system, and so many more people leaving the jail quickly. Would they feel accountable? Would they reoffend more? I understand why people feared that. And, you know, our role is to follow the data. And you know, I guess we've been surprised at how consistent the results have been since day one. You know, it was consistent with researchers who've done studies around the country showing that with low-level cases, you know, people are not low risk, and jailing people can actually cause crime, can destabilize them more. They may be more likely to steal something again or whatever the low-level offense was because their lives get turned upside down. But we weren't sure what we would see. And when you have numbers, so many people, it's such a big system where we're not testing like, you know, 158 people getting some intervention and 72 people getting another one. I mean, this is, you know, it was 50,000 people a year. Now it's about 40,000 people a year. And every step of the way, we see the numbers of arrests and the numbers of rearrests decline. And I think that's remarkable. And people around the country have been watching what's happened in Harris County and viewing it positively. And that said, you know, we continue to see comments made in the press and the like. And, you know, we're not politicians, you know, we're not in the business of responding to political commentary, but we continue to see people say that it's, you know, misdemeanor reform isn't good. All we can report on is is these data, which is incredibly rich and large. And we've also done more fancier causal analysis. There's a wonderful economist on our team who's done detailed statistical analysis confirming the same things that we see in the big numbers. So we always start our reports with that information about public safety. Public safety is not all that matters. We also care obviously about the constitutional rights and fairness of people in the system. But we weren't sure whether public safety would benefit from these reforms, and it's been remarkable how consistently it has.
Yeah, and, I would just add too that, with regard to publicity, it's always easier to get a story out about something that invokes emotion and fear and, those stories sell more than good news stories. And so it's harder, I think, to get the word out that something's working. People say, oh, great, and they just walk away and they're not interested. But, our reports have been getting these numbers out really consistently. And, we feel that if we talk to the community, if we work with the community more, that people will, start to recognize why things are improving. Like why are they not seeing their loved ones having to come up with so much bail money in these misdemeanor cases? And I think it's important to note, again, when we talk in general sense about bail reform, a lot of the stories we've seen in Houston are not about bail. They say it's bail reform, but they're talking about people charged with felonies. There has been no formal bail reform in Harris County for felony cases. No bail reform for felony cases has happened. So why are we talking about a broken reform when there hasn't been one in the felony cases, right? But those are the ones where typically large secured bonds, money bonds, have been set, and then people break bond. But that's not what we're talking about at all, right? And the felonies are a much smaller segment of the overall population. So we're talking about reform at the lower level where we have huge numbers and it's really working.
Bail reform has never been about ignoring community safety. In fact, it's just the opposite of that. If someone is going to be released, that's what the elected judges are doing. They're assessing whether or not there should be conditions placed on that release in order, as I said earlier, to minimize wherever possible. That's what we're called and charged to do. We do that on a daily basis. So I'm always pleased that while the storyline didn't always tell the truth, we know that the numbers do. And we know that if you're ever in a courtroom, you'll see that in action.
That's it. Thank you. Have a good day.
Hello,
So,
Texas Organizing Project. I'm Beverly Venable. How has the consent decree affected the share of misdemeanor cases involving people who are flagged as disabled, be it physical or mental illness?
In general, we've seen a decline in that share. We have better information about that we shared in our last report, and we're really grateful to a number of different county actors, including the courts, for helping us sort of better untangle it. We've seen fewer people over time who are flagged as having serious mental health needs, as well as people who are homeless. That's the good news. The other news, though, is that those are people, especially people who have both, people who are unhoused and also have mental health flags and the like. They're twice as likely to be rearrested within a year. And that's, for someone who's unhoused, who has behavioral health needs, obviously, you think about recidivism in a very different way when you're looking at that population, and it's a important piece of the puzzle. Many of those cases are trespass, theft, lower level misdemeanors, even within the misdemeanors, and rearresting the person, jailing the person isn't going to solve underlying problems. That's why we've been heartened that there have been important efforts in Harris County. Those cases are very taxing on the court system, and those aren't problems that it is easy for bail or for the court system to solve. So we hope that, the county continues to invest in the kind of non-court solutions for people who have those kind of urgent needs.
We would love to have a fully funded misdemeanor mental health court. We work with what we have, but if we had a specialized court that had specialized resources within that court, not just mental health, quite frankly, there are other areas that since 2019 that we would have asked for, requested, and wanted to have. And when those resources are available, we will dive right in and take advantage of it. We know that they will be a benefit to the community.
Yes. All right. Thank you.
Thank you so much.
Hi, good afternoon. I'm Mo Cortez. My pronouns are he, him, they, them. I'm a policy organizer at Grassroots Leadership. And my question to you, I've witnessed several magistrations at the JPC and other places. And I noticed that people, the bail amount is set and things like that. But I was curious if an amendment can be made to Rule 9 to add the ability to argue probable cause, start at the front end to have less people going into the jails. I don't know how many people have died in Harris County Jail this year, but it's not a success. So just wanted to see if you're able to do that.
I think that is being done.
I don't think that.
I mean, certainly probable cause is,
Well,
there's a probable cause hearing.
right, there's a probable cause hearing, so that's being done. So as long as they have representation by the public defender's office, and there's also the prosecutor, so those things are being done at that initial hearing.
No,
Sometimes it's actually continued to be done. So even once the case gets to the 16 courts, there's nothing preventing or stopping that. I hear probable cause daily, on a daily basis.
all right. Thank you.
Yes, sir.
Hi, good afternoon. My name is Montserrat Montalvo. I am the Texas organizer with United We Dream. And our question is, under the SB4 deportation law, magistrate judges are able to offer removal or self-deportation at magistration. How does the county plan to ensure compliance with the O'Donnell Consent Decree if SB4 goes into effect?
Actually, the county attorney's office, we haven't analyzed that question yet. I mean, if a challenge comes into effect, we'll analyze it at that time.
Okay. And then just as a follow-up, are there any specific charges for which magistrate judges are required to offer bonds, or are judges able to always decide at their discretion?
Required to offer.
Well, so, I mean, in general, most misdemeanor offenses, one of the cornerstones of the decree is that you're entitled to get a general order bond. So you don't even see a magistrate. You're bonded out with that general order bond, at the point of booking. But then there are these carve-out offenses, which are specific. And so they can involve family violence, domestic violence offenses, repeat DUI, and then cases where someone is in violation of probation or prior bond, for example. So those are the cases, they call them carve-outs in the consent decree, sort of 6 categories. The subset of, in general, kind of more serious misdemeanors or misdemeanor arrest that violates something else that happened, like you're on probation. Those are the ones that go to a magistration hearing. But once it goes to a magistration hearing, a magistrate is absolutely not bound or required to enter any particular type of bond. What they are required to do is to carefully consider this question, like, is there clear and convincing evidence that this person poses a public safety risk or a flight risk? And so the hearings are a lot, it used to be that the type of offense did matter and there's just a schedule. And if it was a serious assault, $5,000, theft, $1,000. So it really was based on the type of offense. Now it's not. And, the hearings are much longer. They're often, you see, 5-10 minute hearings, not the 30-second hearings. There's a public defender there. And that's what they're talking about in general. Like, does public safety really require some set of conditions here if the person is given a personal bond, or is it so serious that a secured bond is the right option? And then even after that, if a secure bond is what the magistrate chooses, there's a next business day review in front of the judge. So that's another protection. It's sort of an appeal or a chance to get before the judge to raise these arguments a second time.
Thank you.
Hi, my name is Katie Merza with the Immigrant Legal Resource Center. I'm really relieved to see a reduction in the amount of time people are spending in jail for misdemeanors. But we know that even a brief arrest can lead to job loss, trauma, family separation, or deportation. So I'm wondering what further steps Harris County can take to prevent unnecessary arrests in the first place.
I think that's an important prioritization question for law enforcement. And, the consent decree doesn't include them. We have seen, though, this decline in misdemeanor arrests over time. And is it that law enforcement has done some reprioritizing, or is there just less offending in the community? It's a little hard for us to assess that from our end. We have looked at HPD data, which they generously shared, and have the sense that there hasn't been any sharp crime trend in the community that accounts for this. So it's not, it does look like there may be modestly less offending over time, but there may also be changes in priorities. And, I do think there are lessons for law enforcement in some of these cases where if, refiling a case against, an unhoused person, that's not going to change their situation. If the cases really aren't going forward and not having a public safety benefit, then maybe they don't need to be on our judges' dockets. Similarly, in other types of cases where some kind of a community supervision or something else could accomplish the goal, there may be alternatives to arrest that could be considered. There isn't, cite and release isn't built into this consent decree, but there are options like that where people wouldn't have to be brought to the JPC. And that could be a good thing for the people who are in the group that we're studying. One reality is that I think, the architects of this consent decree wasn't us. We came in late after the consent decree was designed and were appointed after it was finalized. But I think the hope was that general order bonds wouldn't take long, that people wouldn't have to wait that many hours before leaving the JPC. And it is routine for people to have to spend quite a few hours, even, more than 12, more than 15. And that has to do with the demands in the JPC and staffing, but it would very much change if some of these cases that are realistically very likely to be dismissed. I mean, if in general the dismissal rate is 70%, there's some types of cases where the dismissal rates are much higher. And there's a question like, are they worth bringing in the first place, or are there other options, alternatives to arrest that would be good for public safety and wouldn't burden the courts or the JPC in the same way?
Yeah, I would just add to that a lot of this, just a lot of the discretion in this area is exercised by the district attorney's office. And some of that has to do with policies regarding acceptance of cases and case screening. And I think we're going to see some changes in how that is done that could be very helpful to get some of the cases that really, you can see that there's either nothing there in the file to justify the charge, or there are better things to be done. And we already have a lot of programs that the DA's office has implemented to try to have these kinds of diversion programs. So that if people complete the programs and they receive some assistance, some resources to help them turn their lives around so that they're not behaving in ways that become a problem for law enforcement, that their cases can be dismissed. So we hope to see more of that.
And where it could be, where we have more post-arrest diversion, but one can also have pre-arrest diversion.
I think, the judges have no involvement or authority in terms of who's going to get arrested and all of that. We don't have any involvement in that. But once it reaches that point, we do have the cite and release program. And that's really about law enforcement and those that choose to participate in that program, right? So the more that do, then they can take advantage of that. And that's an easier process. It's not a complete diversion, obviously, but at least it's an easier process and helps to avoid that, losing your whole life just by going through the arrest process.
Thank you so much. We were also wondering, did you cite statistics on misdemeanor arrests decreasing? And if you did, could you repeat those because we missed them?
Yes. In general, it was about 50,000 people arrested for misdemeanors back in 2015, 2016. And now it's in 2023, it was 41,177 people. And so about a 9,000 person decrease. It's a little different when you look at numbers of cases and not people. And there's always this question, is it appropriate to look at the person level, the case level? Simpler, at least simpler as a starting point to look at people. Similar decrease in numbers of cases. And again, some of that may be decreases in offending. Some of it may also be diversion. We know that, for example, marijuana cases are no longer, misdemeanor marijuana cases are no longer being taken up programmatically. And so that may explain some of it as well.
Thank you so much.
Hi, my name is Katarina Deschert. I'm with the Tahrir Justice Center. We work with a lot of impacted community members who I think would love to be at these meetings, but aren't able to attend for a number of reasons. Has to do with work schedules, language accessibility, childcare needs, and stuff like that. Are there ways that the monitors in the county can make these meetings more accessible to folks in the community?
We definitely can. I was just thinking about this today, potentially, we've always, in the beginning, O'Donnell happening during COVID was virtual. So we've slowly kind of moved to these type of in-person meetings, but potentially having, and maybe the monitors could even participate virtually, and it could just be more on our side, but maybe having some things at the library, maybe, collaborating with some of our partners. So it's definitely a conversation that we could have. So thank you for bringing that up.
Yeah, we'd love suggestions on good locations. And,
Like evening and translators.
yes, evening and with translators. Yeah.
Yeah, interpreters would be really great.
Yes, thank you.
Thank you.
Hi, good afternoon. Krish Kundu, Texas Jail Project. I had two separate questions, one for the monitor and then one for the judge. This is from a community member who sent us online. They want a really simple 3 positive takeaways in the most recent report, and the 3 challenges that still remain that you think are three most important challenges. So the 3 most important positive takeaways that we should be celebrating, and the 3 most important challenges that we still need to address. And then the question for the judge is, you talked about cite and release. What would it take for HPD to actually follow that? Do we need a general order? Like what kind of enforcement mechanism or directive is needed from the county for HPD to actually follow or use cite and arrest? Because if you look at the jail data dashboard, we have about almost 700 misdemeanors sitting in the jail. And the majority of the arrests in the jail are coming from HPD, over 58, 59%. So those are the 2 different questions I have, and
I guess to pick 3, I guess that the main 3 pieces of good news that I highlighted earlier were the continued public safety numbers that repeat, the numbers of people arrested within a year after their arrest, continues to decline. And so I don't use the word, we use repeat arrest, not recidivism, because it's not exact recidivism. Often the person's first case and the case within a year, they're both dismissed. And so it's not like a person was convicted once and convicted again, but there are repeat arrests, and those rates are the same as they've been for many years, and the numbers have declined. The second piece of good news that we reported involves all this work around court appearance and the early really positive results of the electronic court notifications. And the third, which Judge Baldwin also highlighted, was the backlog elimination and how much less time it's taking to resolve these cases, which is important. It's obviously the consent decree isn't about case processing, but we want to see like what are the impacts of these changes have on the courts. So that those 3 things are all positive. There are other pieces of positive news that we've talked about. In terms of challenges to come, one that we highlighted and which we think is important is that a reason why people may not come to their first appearance may be that they don't have a notification, and there's much better ways for them to find out about that first appearance. But also, they don't have a lawyer yet typically before that first appearance. And it would improve everyone's lives in terms of the fairness of that first appearance and the ability of the person to understand what's at stake and why they need to come to court, make things much better for the judges as well, for someone to be connected with counsel beforehand. But the appointment doesn't happen until until the first appearance under the current system. And we also see that affecting the bail reviews and the like, where the person is held on a secured bond, but they don't have they haven't been assigned counsel yet. So we see those bail reviews not always happening, or the person isn't there, or they don't have a lawyer. And so those are, I think there could be system improvements made, because it's sometimes quite understandable that those things happen under the current system. So that's something that we discussed. I guess biggest picture, we kind of can't believe it's been 4 years. There are 3 years left. We would love for the system to be working so that monitors aren't needed, so that Sandy and I can retire. And that really means that that the system works on its own without that when issues come to light, that there's self-correction. So that the system is lasting. And there are a number of ways that the system can be made lasting. It was designed to be lasting, and the hope is that it is. But in general, like the number one priority over the next 3 years is to make ourselves irrelevant. And that there will be some challenges, and that there will be some, I think, resources needed to have the county substitute for the monitor. And but that will be really exciting too.
I think if I could add one third thing, I think it would be just more transparency and efficiencies around court data, or not just court data rather, but like criminal justice data. One of the things that we would love to be able to do is to have a more fulsome vision of all the different agencies that are involved. Right now, we have the data for most, but not all. But I think that we're making progress on that, and we're really grateful that Chief Finner has also shared HPD data, which he didn't have to. But we still have a ways to go with that, and also just ensuring that other advocates like our community justice partners have access to data that's reliable and more complete. And, ideally to have systems in place in the JPC that would enable people who are given general order bonds to be released promptly. I mean, it really shouldn't take a full day for somebody to get out of jail when we know the moment they're going in that they're going to get released on a general order bond. And it's not just like I know people are going to want to point fingers at the sheriff, but there are a number of different agencies involved in the processing of that within the JPC. And it's not really part of our job, but we would love to see that, because I think the spirit of the consent decree was that people would not have their lives wrecked by being in jail needlessly. And, one day and getting out without pain is great, but it's not 2 or 3 days, right, that they had to wait to plead guilty. So they're getting out without pain, but it's taking a little long. So we'd like to see that improved.
Thank you.
As for cite and release, we will obviously continue to work with our community partners, but we really can't force them to the table as it relates to cite and release. So right now, HPD, Harris County Sheriff's Department, are participating. They're about 80% of what generally happens as far as arrest goes with misdemeanors in the first place, right? So they do carry the bulk of the load for that. Perhaps what we could do more, perhaps encouragement from the district attorney's office, perhaps encouragement from the CJCC. They could encourage the other agencies to participate in it, and maybe that would help to grow that system.
Thank you. Appreciate it.
Hey, you all. Somebody couldn't be here today, so I'm just asking their question. They've been involved in a lot of community organizing. I'm with Texas Advocates for Justice. My name is Monty, and they recently took a tour to Harris County jails, and they wanted to know, have you all taken a tour, and has this been part of your data research this year?
I think our tour was the year before last.
Yeah. But
Haven't been
we have
this year.
And you-
talk
In like 20 years going
20 years.
before
What
that.
did you say was interesting? Okay.
I haven't been this year in terms of a tour.
And I think maybe the time after that, we visited some of the courts. We also, we watched video of the bail hearings so that they're recorded, and we kind of watch them at random. And from time to time, there are live streams of district court too. So we do watch the judges sometimes. And so that's very accessible to the public. And here and there, we also, obviously look up cases that come to our attention. I mean, ideally, like as part of this whole idea that, if there are issues that come up in a case that implicate Rule 9, the county actors should be identifying and solving them. There's been real work done on the data team side to develop something to kind of automatically catch a person's case if it seems like something is going wrong. And there's a lot of data work that needs to be done on that. It will take resources to really build that system correctly. But there's been some good work done to develop something preliminary, and so we're really happy about that. So, I remember I was here with a former law student of mine who, in the first year of our work, was looking at cases by hand, just going through the jail roster and reading what was happening because we didn't have that, and we were just kind of by hand looking at one case after another, people in the JPC on misdemeanors to see whether we could understand what was happening in their cases. And we don't have to do that anymore, which is great. And there's no substitute for going in person sometimes as well. And we were just meeting today and thinking about other types of kind of in-person visits that we'd like to do.
Okay. Thank you.
And also to speak on that, there are trainers, so our misdemeanor attorneys and also our judges receive a training, and each year they do take a tour of the jail and they sit in on bail hearings. So some of that information is translated to the monitors. Okay, so I will read, looks like we have one question, well, a two-part question online. It says, how will this process help alleviate the issues with the jail information management system, gyms, and managed assigned counsel? And it seems like there was a follow-up for, will this decree hold the justice of the peace accountable for abusing their authority? And I think that was maybe kind of a part of that first question. And I think when they say this process, they're referring to just O'Donnell as a whole.
Oh, yeah, we definitely don't have any, relationship with justices of the peace. So I don't know if there's some other consent decree or some other litigation surrounding that, but.
General about compliance and.
Yeah, I'm not aware of anything.
Yeah, we're not aware of compliance issues concerning those data systems either.
Okay.
I mean, I guess I would add that, we're monitors. So our
Right.
job is to track the data, to inform the public about what's going on. And we have reports that we post online that are available where we have noted some issues, regarding different agencies' involvement. And some of those get corrected through that process, just communicating with officials about what we're seeing. And oftentimes making note of what's happening will be enough to inform the relevant parties of concerns that are being raised. And we have a website where people can reach out to us and let us know if they're seeing something that concerns them. Then they can also let us know. But otherwise, this is a court settlement that really doesn't get enforced as such unless the parties choose to do that, and that's not really what we're about.
Okay. Our next question, for people that are proven innocent, are they compensated for lost wages, loss of employment, or any other life-altering issues?
I mean, there is Texas legislation, which is actually quite good compared to legislation in other states that can compensate people if they meet a definition for having been exonerated.
Said, sorry,
It's called a Tim Cole Act.
Tim Kolak? Okay.
It's COLE.
CO,
And it really is something.
Tim
Texas-
Cole Act
Texas has
for the
justified
online
kind of-
audience.
Yeah, but that really would be helpful, like for people who've been wrongly convicted and incarcerated for long periods of time, because the amount of compensation turns on the amount of time that they spend behind bars. So, yeah.
And it's a pretty high burden, like the question was phrased, proven innocent. So if you're proven innocent, the Tim Cole Act would kick in. But if you're found not guilty, that's a different legal term.
Gotcha. Okay.
I know that sounds confusing.
Okay. So Jasmine with Texas Rising and Houston Leads. According to your data, what is the most common offense that non-citizens are detained for in Harris County? And do these top offenses qualify to receive a citation? And if so, why are people arrested instead of receiving a citation?
It's a great question about non-citizens and the most common offenses. I don't have that in front of me. We have just more general numbers, like on immigration holds, for example. But I guess on citations, that goes to this conversation earlier where it's really not, it's law enforcement discretion whether to refer people for a citation or not.
Okay. Next question. How can it be?
Let me just add,
Yes.
if I could, that over time, we have taken more, we've sliced and diced the data in more and more different ways. And so a question like this is really helpful because we might not have thought to pull the data apart to look at that question, but we could do that. So we're making notes right now. So thank you for the question.
Okay, next question. How can it be ensured that probable cause and reasonable suspicion are actually legitimate before making an arrest? Bias and inaccurate accounts leave people, especially minorities, vulnerable to arrest, which can exacerbate already existing issues like poverty, health conditions, employment, etc.
I mean, the probable cause requirement is not really a part of our consent decree. We certainly, as law professors who teach criminal procedures, like we all agree that probable cause is an important step. It's important that there be probable cause. It's not the most demanding standard, right? It doesn't require anything like absolute proof. Certainly an important step in the process for a misdemeanor case and for any case. But it's the consent decree doesn't, add new guidelines around probable cause determinations or anything like that.
Yeah, no, it's really, in this county, that would be a determination that's made by the district attorney's office. And they have had lawyers doing those kinds of screenings, to try to ensure that there is probable cause. If that's not, I don't really know what else to say about that other than we already are having those screenings. And then again, people are going before magistrates who are also screening the cases pretty promptly. So.
And then it can be raised again in front of the judge.
And then they get raised again in judges' courts like Judge Baldwin and her colleagues, the following day. So they're getting at least 3 levels of screening that's pretty prompt. So we would hope that it's being done correctly at that point.
Okay. I think we have 3 more questions. So sorry. Yes.
I don't have a question so much as a comment. We've had a lot of questions today about the probable cause determination. And I think part of the reason for that might be that Chronicle article about Kim Ogg's administration and the thousands and thousands of people who were charged and eventually dropped. And that is a very good reason why we should exert pressure on the new DA coming in on that issue, because like they've said, it's a little bit outside the wheelhouse of the O'Donnell Decree.
Thank you. and this, another question kind of around this, but if SB 4 is allowed to take effect, how will you, as a judge or officer, assess probable cause for enforcement? Are there any specific charges for which magistrate judges are required to offer bonds, or are judges able to always decide at their discretion? And I'm not sure.
Yeah.
Okay. Okay, Terry online, they did answer that earlier, so I'm going to move on to your next question. We have noticed more ordinances that criminalize homelessness, particularly the civility ordinance, which bans people from lying or sitting on sidewalks in certain sections of Houston. How has the O'Donnell Consent Decree helped low-risk individuals who are struggling to make ends meet stay out of jail?
The consent decree doesn't speak to how, ordinances impact homeless people. I guess the main ways that the O'Donnell decree intersects with homeless people or anyone arrested for misdemeanor, though, really is the ability for people arrested for low-level offenses to get a general order bond. On the one hand, we do see in our data too that, homeless people disproportionately are arrested for GOP eligible low-level offenses like theft, trespass. Then again, they're also more likely to be repeatedly arrested, which may place them in the category of a carve-out where they're out on bond and then come before a bail hearing. So we do see unhoused people cycling more than people who do have addresses. And so in that sense, the consent decree doesn't offer any special help to them. I mean, the idea of having a specialized misdemeanor behavioral health docket, homelessness docket, right there might be other interventions that really could be focused on those vulnerable populations.
Yeah, we want to continue to have conversations with, stakeholders about other sort of diversionary type programs. If someone is being arrested for an offense and it's clear that the root cause is that they have nowhere to live, that maybe instead of taking them to the JPC, there are more resources devoted in the community. And Houston, by the way, is doing a great job. I mean, there was also a Chronicle article about Houston's doing a great job on homelessness in general. But we're still seeing some issues, right? In the numbers in O'Donnell, it's an ongoing social issue. So, giving law enforcement more options in terms of how they respond would be kind of a city and county-wide challenge. But clearly, law enforcement is responding to community concerns when they're arresting people. And we just, as a community, need to give them more clear direction about effective interventions that they can direct people to, rather than, using handcuffs and jail.
Okay. We know that time in jail can destabilize families who lose employment or force children to move away from home. Do we know anything about the individuals who have benefited from reforms as far as employment status as a caretaker that helps us quantify these other benefits of reform? Do you have any of those stats?
We'd love for people like that who benefited to get in touch with us and share their stories. Certainly, some of the community stakeholders here or who meet with us otherwise have, anecdotally passed on powerful stories along those lines. And we would love to report on them more in our monitor reports. That's definitely a priority of ours, is to highlight experiences of impacted people in our future reports. In our work, we are trying to quantify the reduced costs, community costs, loss of employment, loss of income, and the like, which we think are quite substantial, and we're working on providing those kinds of calculations. But we would love to hear from more people. We do have that form on our website. People haven't used it very often, although they've used it a little bit here and there in the last month. But it's not just a complaint form. People can report on positive ways that receiving the GOB and made it so that they could keep their job and work out their case. And we suspect that these changes have meant a lot to some people, even if, you know, I guess someone who hadn't experienced the old system might not appreciate that this is very different. But we would love for people who have seen the difference and it's made a difference to their themselves or their family. We'd love for them to tell us because I think those are important stories.
Yeah, I mean, you know, once again, it's a lot easier to find really scary stories and bad, you know, things bad that happen. But we're grateful. We're excited. We learned today that the Texas Jail Project is going to have some videos that are going to be released online. That they've been talking to people in the community who have benefited. So they'll have a lot of positive stories that they'll be able to share. And then we've gotten stories through our partners, you know, about there was a foster kid, a juvenile in the jail. And, you know, this was before O'Donnell, and he would have been entitled to be released quickly today. But when he was arrested instead, he was in the jail. He got sexually assaulted, and, you know, his whole life he got HIV. His whole life sort of spiraled out of control. He ended up starting a fire in the jail and having a felony put on him. And so, you know, finding the negative stories, even with regard to the need for bail reform, we can do, you know, those are out there that we know, as many of you have asked about these problems that happen. They can be very tragic. We all remember Sandra Bland, you know, who killed herself after 3 days in jail because she couldn't afford the $5,000 bond that was set on a charge that shouldn't have been brought in the first place. So we know that those stories are out there, but we would really like to document some of the good stories about people being released and able to get back to their children and their jobs. So thank you very much for the question.
Okay, well, we have reached our time. So we are going to wrap up. Thank you again so much for everyone who has attended in person and online. And we look forward to seeing you all next year at the next public meeting. Thank you.